A very good evening to everyone. I welcome, I warmly welcome you all to the final day, that is fifth day of our workshop on mood code. It is a pleasure to have you all with us once again. I also extend a heartfelt welcome to Ms. Manvi Datta ma'am as she takes the virtual stage to begin today's session. Over to you, ma'am.
Thank you so much. So today we will be talking about the last aspect that we have talked about yesterday also. That is the courtroom manners and how to succeed in a moot court competition. So what are the key factors which help in in winning the moot court competition, and also what is the oral professionalism that you have to follow, the decorum that you have to follow in a moot court, in any moot court competition in a moot court hall, right? So getting on to that, first of all, I will just share the PPT, and before that, I just want to ask you that what are the key things that affect the decorum in a moot court competition? For instance, if judge asks you certain any question, then in what way you should answer? Okay. See, today we will talk about the courtroom mannerism. Okay, how you will succeed in a moot court competition, what are the common mistakes which are being committed by each and every team members, and what are the best practice just to evade those mistakes. Then we will talk about the review and feedback session. That is how a mock moot court session with evaluations can help you to enhance your skills as well as to uh, develop advocacy skills, and also to understand the legal procedures. Then, lastly, sorry, lastly, we will discuss about the question and answers with experienced mooters, or question and answers with the faculty members, so that they can address any doubt or they can share their expert strategies regarding the moot court journey, right? So, getting on to that. Okay, so is it visible?
Yes,
Yes,
ma'am,
ma'am.
it's visible.
Okay. So first of all, we will understand the courtroom etiquettes that we have to follow. So, importance of professional conduct in a moot court competition is very much important. That you should always be credible. You should always throw a professional decorum. That is, a professional decorum will be maintained in a way wherein you should be properly dressed first of all. Okay, and you should always behave in a manner that is showing your professional conduct. That is, you should always be polite, you should always be respectful in front of the judges as well as to your opponent as well. Okay, so importance of professional conduct is, that is your credibility through demeanor. That is, as a lawyer, you should be respectful. You should be respectful in form of any communication with your judges or with the opponent, and you should uh, these things should enhance your credibility in court. So this is very much important, and this is one of the criteria which enhances your personality as well as your conduct And also it is a major factor in influencing the judges regarding your perceptions, and also it will influence them to um help you. That is, they might give you good marks, and they might help you to qualify in the further rounds, right? Then comes key courtroom behaviors to adopt. So the key courtroom behaviors to adopt are, first of all, you should be respectful. Whenever you are interacting with the judges, it must be you must be very respectful. You must engage the judges with formal titles, that is your excellency, your lordship, or your ladyship, however. And also you should enhance the advocate's credibility, as well as how to promote effective communication during the proceedings. That is your conduct, how you will adopt it, how you will conduct it, that is on you, right? Then how to maintain a composure and clarity, that is, you should always be calm and composed, and whatever you are stating in a court should be with utter clarity. You should be clear of each and every component that you are sharing, each and every legal aspect that you are contending. And also, you should never feel pressurized or nervous. You should always remain calm. That is the main key whenever you are presenting your contentions in your oral advocacy. And also, it is a part and parcel of your courtroom mannerism. Then, talking about the dress code for moot court competition. So, it should be purely professional. That is, the Western suits, okay, the formal suits that you have to wear, the business suits. And advocates always must prioritize a polished appearance, as it reflects their seriousness, also the respect for the legal process, the legal conduct that they are contending, and it should influence the perceptions of their competence as well as professionalism. Then the courtroom dress code for women lawyers. Okay, there is a separate courtroom attire for women lawyers. There are following specific dress code. Either they can go for any Western business suit, right? Or they can wear a kurta as well. In Indian courts, you might have seen that women lawyers are wearing kurta. But in a moot court competition, it is recommended to wear the suit, that is the business suit, that is recommended. Then the initial visual impression that is being created by any advocate can significantly affect the reception of their arguments, as well as their scoring, as well as the importance of appropriate dress in courtroom settings. So it is also very much important to follow a proper dress code whenever you are participating in a moot court competition. Then comes common etiquette mistakes that every team member might have conducted. First is preparation is key. So adhering to a conservative dress code demonstrates respect to the court and also enhances the advocate's professional image and credibility. So you have to be prepared. You have to be very much prepared that what you are wearing, what you are addressing before the court, that is your personality which is being thrown upon and which is being represented by you in a particular round, right? So you have to be presentable before the court. That is the key thing. Second is when you are familiarized with the preparation, that you know what you have to say, you are clear with the concept, you are clear with the contentions, you are clear with the arguments that you have to contend it before the court, then accordingly you have to follow the protocols, the rules and regulations of the moot court competition. That has to be followed adherently, and you should adhere to each and every rule which has been guided, the rule that has been given to you, right? And thirdly, it is always recommended to maintain a eye contact, and you have to address judges appropriately as to foster a respectful atmosphere. And it is a crucial it is also crucial for effective communication and successful advocacy. So it is very much important. Then comes another part which is very much effective in courtroom mannerism and success, that is strategies for effective mooting. So what are the strategies? So here we will see from the judge's perspective that what are judges looking for in a moot court competition. So as per the judge's perspective, first of all, they are looking for comprehensive legal understanding. That means that whatever legal concept, whatever legal knowledge, whatever relevant statutes or relevant materials that you have shared, that you are constructing, should be comprehensive, should be to the point, and you should be having depth of knowledge regarding that legal implication that you are contending to, and you are very much clear about what you are saying, what you are presenting, what you are contending before the court. Then comes legal argument, how you will present the legal argument. So legal argument shall be presented with utmost clarity and organization in presenting arguments, that is, which are if you are presenting any argument which is very crucial, and judges can favor advocates who can articulate their points in a very structured manner, in a very coherent manner. So uh, if you are presenting any such argument which is very crucial in nature, which is very complex in nature, and which has many subparts, and it is very difficult to crack, then judges will favor you as you are able to articulate in a very effective manner, in a very structured manner. That is also a plus point while presentation your argument. Then comes confidence and professionalism. So whenever you are present in a courtroom, it your presence should be materialized in a way that you are seeing you are seeing presentable, as well as you should be your engagement should be respectful in a manner that you are very much you are paying attention to whatever judges are asking you, and also you are creating a mark on the judges, an impression on the judges, as regards to your courtroom decorum, as regards to your presentation, as regards to your confidence, as regards to your whole personality, which is being described in a courtroom. Right? Now we will talk about 5 common mistakes and how you can avoid those common mistakes. First is engage in extensive legal research to ensure a deep understanding of case law and principles, avoiding superficial knowledge that can undermine arguments. So that is very much clear, that we have already discussed while we were discussing the first part of the moot court competition, that is the legal understanding and legal research. So your legal research should be so much extensive, and so much you should have a deep knowledge, deep understanding of whatever legal research, legal network that you have developed through case laws, through principles, or through any other references that you have referred to. You should never your base, your research should never be based upon any such superficial knowledge which has no basis, and which will in a way which will undermine your arguments. Secondly, you should prepare concise notes that emphasize key arguments. Now, when you are making notes, you should always keep five things in mind. That is, you should always write whatever notes that you are taking and never type. Then, you should always write key concepts and not the full sentences. Then, try proven note making methods, that is outlining, Cornell, mind map, that you have to always use. And lastly, you should engage with your notes, whatever you are making, whatever note utilization that you are doing. You should be fully engaged, fully effective with note utilization. Lastly, you should be very strategic with the time allocation. So, whenever you are preparing, whenever you are practicing your oral arguments, you should be very much aware, very much cautious towards the time of your speaking. Each contention should not be so for each argument segment, you should practice it with a timer so that you may not tend to exceed the time limit in the actual courtroom. So these are the common mistakes that you must always avoid while participating in a moot court competition. Then moving on to best practices for preparing your arguments. So best practices is uh, through issue indentation, that is thorough issue indentation is required. That is, you should always be able to point out the legal and factual issues within a moot court problem, which is very much essential as it lays the groundwork for developing focused and persuasive arguments that might resonate with the judges. Secondly, you should have comprehensive research techniques, that is, engaging in extensive legal research not only strengthens the argument, but also it equips participants with knowledge to anticipate the counter arguments. And this research, this comprehensive research techniques will conclusively have a overall effect on your oral structure. That is, your structuring of the argument should be very clear and logical, and your manner in that logical manner that may impersonate the judges in your favor. That is, they are ensured that each point is substantiated with relevant legal precedents and effectively addressing opposing viewpoints. So you should be very careful while structuring your logical argument, that is your legal argument with logical precedents, with legal precedents. So your arguments should be always be structured with the which is all sorry, it should be always be substantiated with relevant precedents. Then only you should have a base, like whatever you are contending has a support to it. That's why you are contending in that manner. Then comes techniques for persuasive oral advocacy. So, audience centric argumentation, that is, tailor arguments to align with judges' values and expectations, ensuring clarity and logical progression to enhance engagement and facilitate understanding of complex legal issues. That means that whenever you are trying to present your arguments, your arguments should be audience centric. That is, you should be able to persuade, and you should be able to um, turn to the expectations of the judges, that you are ensuring that clarity and that logical persuasion over the judges, that they are able to understand. That doesn't mean that if you are speaking in a manner, if you're presenting in a manner that is not at all being understandable to the judges, neither it is facilitating any understanding or any engagement to the audience. So your argumentation should always be audience centric. That is, you should be very simple with your arguments, uh, and if your legal issue is very complex, then you should have adopted a structure in a way that that is facilitating understanding for your complex legal issues. Then talking about the dynamic presentation skills, so you should always utilize varied tone, uh, body language, so that it should maintain the interest of the audience. That is, audience in your case will be the judges. So you should always emphasize key points and foster a compelling narrative that resonates with the judges through advocacy. That means that you should be very much compelled with what you are contending before the court, that it is so much persuasive for the judges to agree, and they the judges will resonate with those issues through your oral advocacy. So these are the few techniques of persuasive oral advocacy. Then comes the last part, that is engaging with the judges and the feedback. That is the last part of oral advocacy and the presentation, courtroom presentation. That is handling of the questions from the judges effectively. Now, how you can handle the questions? First of all, by preparing anticipated queries. So you should always employ techniques such as paraphrasing the judge's question. Now, what do you mean by paraphrasing the what do you mean by paraphrasing? You know what is paraphrasing? Anyone? Paraphrasing simply means to restructure the sentence. Okay, restructuring of the sentence. So if you are paraphrasing the judge's question, that will be helpful to you to ensure accurate understanding and to formulate precise responses that addresses the inquiry directly. Secondly, you should be always develop a comprehensive list of potential questions that may be based upon case arguments, so that you can enhance your confidence, and you are very much prepared, very much ready with the anticipated questions that might arise from the contended arguments as well as the contended legal issues. And you should always utilize a clear framework for answers, including a brief introduction, main argument, supporting evidences, and a conclusion to enhance clarity and persuasiveness. That must be there. Then comes importance of rehearsing and receiving a feedback. That is a critical preparation for advocacy, that is engaging in rigorous rehearsals and actively seeking constructive feedback is very much essential in a moot court competition, because it can enhance an advocate's ability to present and to compel the legal arguments, ensuring the preparedness for dynamic challenges of moot court competition. So, it is very much important for you to engage rigorous rehearsals in which you can anticipate what answers, what constructive feedback are essential, and upon on the basis of those constructive feedback you should work upon the lacunas that you have as a team member, and this will enhance your ability, your oral advocacy, as well as your ability regarding legal research or how to compel and legal argument. So this is very much important. Now, learning from the experience, that is, whenever you are participating in a moot court competition, you always learn. It is a learning experience. It is a journey wherein either you gain or either you lose. So, if you are losing, then you should always have a sportsmanship, a sportsman spirit, that you should always acquire some learnings from that journey, the journey from the moot court competition, and this insight in the courtroom dynamics ultimately enhance your readiness for real world legal practice. Now, one second. These are the videos. So this is what is about courtroom manners and mooting success. Now, yesterday, some of you have asked me about how you will detect the overlapping overruled cases on legal databases. So this is how you can detect from SSC Online. Wait a second. Are you able to listen?
Yes, ma'am.
Wait, I'll start it again. Is it audible?
No, ma'am. Video is not audible.
It is not audible. Okay, so you are able to read what is being told, right?
Yes, ma'am. We can read it.
Please do that.
Ma'am, I have a question.
Yes, yes. Tell me.
Ma'am, actually, I want to know about the footnotes which we used in the during moot court memorial preparation.
Okay. See, regarding the footnote, if you are using any legal precedent, if you are using any case law, if you are using any reference from any book, then in that case, your footnote should be accordingly. If you are using case law, then the name of the case, then the citation will comes in the footnote. If you are using any such reference of any book, then that reference, the book's name, the chapter, or any the author name and the publication house will comes along with the um, uh, in the footnote section. Similarly, if you are citing any journal or any other article, then the name of the journal, the publication, and the number, you should mention that in the footnotes, right?
Okay, ma'am.
So, are you able to comprehend this? Is there any doubts regarding this video? Anyone, any doubts?
No, ma'am.
Okay.
Ma'am, one more question, please.
Yes.
Ma'am, actually, I want to know if we are using some source that is for citing some facts or facts, then if we are don't have that article knowledge of that the act or something, then we can we just only put the citation or we need to put the article as well?
See, you should always mention the article that you have referred to. So
Okay.
the name of the article plus the publication where it is being published, the publication house, the name of the journal where it has been published, right?
Okay, ma'am.
Okay. Yeah. So have you like now are you able to understand how you can find out overruled cases on SCC online? Yes, any doubts regarding this? Please answer if you have any doubts, or should I move forward?
No, ma'am. No doubts.
Okay. Now, how you can check if a judgment is overruled on Manupatra. All right. Now, this red flag it is a sign of being overruled. Okay, on Manupatra. If any case is not having such flag, that is it is not overruled. Otherwise, if any judgment is having a red flag on Manupatra, then it seems that that case is overruled. This is an example. So hereby you can see which case has overruled such judgment. Yes. So now are you clear with it? Is everyone clear how you can check a judgment? How a judgment is seen? Overruled judgment can be find out on Manupatra. Is it clear?
Yes, ma'am.
Okay. Now moving on to Westlaw. Have you heard of Westlaw?
No, ma'am.
Westlaw is also a legal database which compiles of the all international judgments, right?
Ma'am, there is one request.
Yeah.
Ma'am, please kindly share these videos to the WhatsApp group also.
Yeah, I will share the whole PPT and you can have a look of these videos as well in the PPT only. It is intact in the PPT. So don't worry, you will have the PPT with you. Okay?
Okay, ma'am. Ma'am, one more doubt about the jurisdiction.
Yes.
Ma'am, when we talk about the jurisdiction, in some cases, there will be the multiple, although we cite only the one court in which we are filing the case, but somehow, sometimes the articles and sections are different and many. So, how we can show that or cite it in the memorial?
I didn't get your question. Like, what are you trying to ask? Like, if we have several jurisdiction in one problem.
I mean several articles or sections.
Acha. So you should always go for prescribed jurisdiction, which is there. That, for example, if it is a criminal case, you should always go for
Yeah.
CRPC. If it is a civil case, you should go for CPC. Similarly, if it is any other case, if it is regarding your human rights, fundamental rights, so you should go as per constitution. So it depends
As per
on the filation of the case. Right? It is being filed in which court, first of all, and it is a criminal case or a civil case, or it is a writ jurisdiction. So you should determine jurisdiction of the case, right? And then
okay,
only you will
okay,
to comprehend that which under what jurisdiction it is being lying to.
okay, ma'am.
Okay.
And lastly, ma'am, I want to know when we talk about the courtroom decorum and its etiquettes. So, I think many of us are the new ones who have not just joined any any moot court competition yet. So I want to know that when we just started our moot court competition, then the terms we used that the council seek permission, and after that, ma'am, should we directly start from the argument advanced, or we have to ask about the facts or that from the judges only?
So, whenever you are
Somehow it is different. It is थोड़ा बहुत confusing.
okay. So, whenever you are presenting your case, you should first of all address the judges, your ladyship, your lordship, all right, your excellency. With your permission, the court want the team the petitioner wants to start its contentions, right? Then the judges will answer yes, permission is granted. Then you will proceed. So, with your permission, Your Excellency, with your permission, the petitioner will would like to ask to whether proceed with the statement of facts or directly can move on to the issues concerned. So, if they said permission granted, then you will respond much obliged, and then you should start with the contentions, right? So you should be very polite whenever any question is being asked to you. Then also you should um, address to the judges, much obliged, and then you will answer. All right.
Yes, ma'am.
Okay. Okay, so is it clear how you can find out how you can filter your searches on any legal databases that is available to you, right? Now, moving on to the memorial. You guys asked me to show a sample memorial. So, this is the sample memorial. That is, first of all, the cover page. Page talks about the moot court competition, the name of the competition, then the team code, then in which court it is being contended, it is being filed, and then the number of the case and the name of the parties. Okay. Lastly, it will be written memorandum filed and submitted by the counsels of for the petitioner, and this is how you will design your cover page. Okay. So this part will, the name of the moot court competition will come as a header and a footer similarly. And now this is the table of contents, that is index of authorities with page number, then statement of jurisdiction, statement of facts, statement of issues, summary of arguments, arguments advanced. So you should always uh, prefer such chronology that the list of statutes must be always with the Roman numerology, and then the actual numbering should start with the statement of jurisdiction. Okay, this is how your index of authority looks. Then coming on to uh, the listing of index of authorities, that is list of statutes or list of legislations, list of abbreviations and acronyms. This is how you can define abbreviations and acronyms. Then books and commentaries. Then e-material, the electronic medium, list of cases, and list of cases should always be in chronology, like from A to Z. Then comes the statement of jurisdiction. Here, you can provide a footnote if you want to provide the whole section in the footnote itself. All right. Then moving on to statement of facts. Statement of facts can be point wise or in paragraph as per the discretion of the team members. Then comes statement of issues. Here they have used 4 issues. All right. Then the summary of arguments on the basis of those 4 issues. That is how the summary of arguments look. Then comes arguments advanced. Arguments advanced is always aided with additional references. So here you are supporting it with the case laws, and case laws should be always presented like this in a footnote. So you were asking how you can present a footnote. Here has you can present a footnote like this in a summary of arguments. Wherever you are referring to any case law, wherever you are referring to any such additional material or additional legal precedent, then you should um, write footnote like this. This is how your some your arguments advance look. Does anyone know what does IBIT means? Hanji, anyone knows what do you mean by IBIT? Hanji, anyone? Please respond. So this is the most important aspect that you can use in your memorial. So if you are not aware, please say that you're not aware. I will tell you what it is.
No problem, ma'am.
Okay. See, IBID means that it is already present. It is already there in the text. That is, for example, it is, if they have used IBID, that means it is a part and parcel of this case law, right? So you can use IBID instead of referring to the same references again and again. You can write IBID, right? Here they have defined Article 5, so you can define if you want for any particular reference that you have made. Here they have referred to Article 5, so they have defined what is Article 5 of the convention says. So this is all about the arguments advanced. Now this is the prayer. This is how the prayer looks. Wherefore, in the light of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court that it may graciously be pleased to, and these are the reliefs that are to be asked with the court, and all of which is most humbly and respectfully prayed. That is, you should sign here. That is the counsel for petitioners. So this is how your memorial should look, right?
Yes, ma'am.
All right. So now, any question you can please ask. Yes, any questions, please ask.
Ma'am, there is from my side there is no question, but a general request.
Yes.
Ma'am, if you do any other workshop, So kindly let me know, as your this workshop is very much helpful for us.
Okay, I'll let you know. You can contact me through my LinkedIn profile as well.
Okay, ma'am. And can we get and if you don't mind, can we get your number as well?
You can ask the Legal Vidya team. They can provide you the same.
Okay. Thank you so much, ma'am.
Okay, you're welcome. And I'm sharing you the content with you. Is there anything else that I can help with? It was a very nice experience sharing my knowledge with you guys. And I I suppose I assume that whatever I've told you is helpful to you, and you must have gained something. You must have some insight with this session, with this workshop. And I wish you all the best for your any future engagements, any future endowments that you have.
As we come to the end of this insightful workshop, I would like to invite our Chief Human Resource Officer, Mr. Paris Chuk sir, to formally extend the vote of thanks to our speaker and all attendees.
Thank you, Karan, for inviting me to delivering the vote of thanks. I am audible to you.
Yes.
As we come to the conclusion of our 5-day workshop on Moot Code, it is my privilege to extend a heartfelt vote of thanks on behalf of Team Legal Vidya. This workshop has been an incredible journey of learning, skill building, and interactive discussions, and would not have been possible without the collective efforts of everyone involved. First and foremost, my deepest gratitude to our distinguished speaker, Ms. Manvi Datta ma'am, who have generously shared their expertise guiding our participants through the nuances of moot court advocacy. Your insights on research, drafting, and oral arguments have provided immense value to all aspiring mooters. A special thank you to all the participants. Your enthusiasm, curiosity, and dedication made this workshop a truly engaging experience. Your active participation and willingness to learn reflect the bright future of the legal profession. Also, I would like to thanks to my our host, the Karan Chetri, for hosting this workshop in a very well manner. We also extend our sincere appreciation to entirely the team for their relentless efforts in organizing this workshop. From coordination to execution, your hard work ensured a smooth and enlightening experience for all. Finally, a big thank you to our technical and support team for handling all logistics efficiently, ensuring that the sessions ran seamlessly. As we wrap up this workshop, we hope the knowledge gained here empowers each of you in your moot court journeys ahead. We look forward to seeing you excel in the courtroom, both real and virtual. Once again, thank you all for being a part of this learning experience. Stay connected, keep learning, and happy mooting. Over to you, Karan.
Thank you all and all the best.
Thank you, ma'am.